This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the Court of Appeals. Take just a moment before we get started and go over our procedure. Then we'll call the first case and begin arguments. I know we have experienced practitioners here, but I always feel more comfortable after we've discussed how we do or how we proceed. First of all, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may do so. You may reserve up to 5 minutes of rebuttal time. Proper way to do that, though, and I feel the need to say this, is you don't request rebuttal time from the clerk. You request rebuttal time from the court. Clerk can't give you any rebuttal time, so request it from the court. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. There is a lighting instrument on the panel. Once you begin your argument, the light will turn green. As long as the light's green, you've got plenty of time for your argument. Once a light turns yellow, it means you're running out of time, and once a light turns red, you are out of time. And we ask that you please respect those time constraints. One important thing that you all need to be aware of, and that is these arguments are being live streamed. So think about what you're saying before you say it. Once you've said it, it's out there for the whole world to hear. And unfortunately, we've seen some situations in oral arguments that people have said some things that perhaps they wish they had not later on. So I just say that for your consideration. Your panel this afternoon consists of Judge Carmen McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we call the first case?
No, Your Honor.
You may call the first case, please.
Kimberly Urquia versus Eric D. Neal.
All right, we will hear from the appellant.
Thank you, Your Honor. Good afternoon. I'm Jimmy Blunt from Memphis. I'm here on behalf of the plaintiff and appellant, Ms. Kimberly Urquia. If I could please reserve 2 minutes for rebuttal.
2 minutes. You are a man who's sure of himself then.
Well, it's not that difficult of an issue, Your Honor.
There are many people who have thought the same thing.
Well,
today.
and I'm sure that they've been proven wrong, and hopefully I won't be, but we'll see. Your Honors, this is a case involving a uninsured motorist, defendant Eric D. Neal, and was involved in a car wreck with my client back in June of 2022, and we filed suit on behalf of Ms. Urquia on November of 2022, well within the statute of limitations, and we issued a summons to the defendant, Mr. Neal, as well as a summons to the uninsured motorist carrier, the unnamed defendant in this case, in November as well. The summons was returned we got service for the uninsured motorist carrier, but the summons was returned for Mr. Neal, stamped not to be found, and that's the issue in this case. The summons was returned, and so since it was stamped not to be found in this county, then we went on ahead and presumed that we had complied with the uninsured motorist statute 56-7-1206, section D, which states that in the event that service of process against uninsured motorists, which was issued to the motorist's last known address, is returned by the sheriff or other process server marked, quote, not to be found in my county, or words to that effect, then the service of process against the UM carrier pursuant to this section shall be sufficient for the court to require the insurer to proceed as if it is the only defendant in this case. And so that's what we did. And then about a year or so goes by, and then the defendant, the uninsured motorist carrier, filed a motion for summary judgment in this case, alleging that we had not achieved proper service process within a year, and in effect let the statute of limitations run. And the grounds for that was that because in the summons that was returned, not only did it have the stamp not to be found after diligent search and inquiry, but it also had a note placed on it by the private process server saying, it said, avoiding service / said he would not cooperate, and then gave a telephone number. So the basis for the motion for summary judgment was that because this was the defendant was evading service as opposed to not to be found, that we could not avail ourselves under the protection of the 56-7-1206D, and instead were subject to Rule 4 process regarding evasion of service process, and then also that the 56-7-1206 subsection E would take effect. That section says that in the event that the uninsured motorist's whereabouts is discovered during the pendency of the proceedings, an alias process may issue against the uninsured motorist. In such case, the uninsured motorist shall be allowed a reasonable time within which to plead to the original process, and the case may proceed against the uninsured motorist as if the motorist was served with process in the first instance. So the trial court heard this and granted the motion for summary judgment, basically ruling that because the private process server, despite the fact that there was the stamp as required by subsection D of the statute, because he put on this private process server, put this note avoiding service / said he would not cooperate with the telephone number, then that would trigger subsection E, because that note indicates that the defendant, the uninsured defendant, his whereabouts were known. Well, Your Honor, my basic argument is that that's an error, because nothing in that private processor's note on the summons indicates that the defendant's whereabouts were known. Nothing in that note confirms that he was in the address, his last known address, as was listed on the summons. Nothing on it says that the defendant in any way could be found. And in case, the note indicates that it's just the opposite, that the defendant was going to do everything within his power to make sure that he would never be found. And so, therefore, it's our argument that we still meet the criteria of the statute subsection D, and because the summons was stamped not to be found as required.
Did you take any action because of the inconsistent statements on the summons?
No, sir, I did not.
The process server was not deposed or anything?
No, sir, he was not.
And this was a private process server?
Yes, sir.
I note from a review of I think the briefs or the records, there were, let's see, there were 2 summons issued, were there not?
Yes, sir. One summons was issued with an address, and then there was another alias summons issued shortly after that was never returned. The first one was returned, not to be found, and so...
That was in November 22, 22.
Right.
And then there was one issued on February 14, 23.
Right.
That was never returned?
That was never returned. And then the summons was returned on this, the first summons was returned February 14, 2023.
Okay. So what is the legal significance then of a summons that has 2 inconsistent notations on it? Because there's no way you can read not to be found and evading service.
I submit that we complied with this letter of the statute under 56-7.
With all due respect, what does the law say about that?
Well, I have not been able to find a case on point. I don't believe the defense counsel has either. There's nothing that we can find consistent with the facts of this case. Every other case, though, says that so long as the plaintiff complies with the letter of the statute, that's sufficient to say, to move forward with the case as against the carrier.
Well, I found a couple of cases that I think are kind of interesting about that.
Okay.
So, and most of them deal with what the private process server can actually, or what the process server can actually say. So is that an issue or a concern?
Well, I mean, it's certainly a concern. I don't know, though, that anything that he said in the summons that we're dealing with would indicate that the whereabouts of the defendant, the uninsured defendant, were known. And that's the whole point of that subsection E, and the trial court relied upon in granting the motion for summary judgment. So,
Well, let's see. Seems like to me this is pretty straightforward. Avoiding service said he would not cooperate, 901-262-7602.
yes, sir. I don't really, I mean, other than he apparently had some conversation with the defendant, the uninsured defendant. We can assume it wasn't in person, because otherwise he would have served the defendant.
But we don't know, right?
We don't know. We can only presume that he called, I presume that he called the uninsured defendant by a telephone number that was listed on a police report and got a hold of him and was told that you were not going to serve me. But that doesn't say that he was known to be at his last known residence.
And trial court granted summary judgment.
Yes, sir.
So how does that work as far as this, these notations on the summons?
You mean, how does the trial court?
How does the summary judgment process apply when, as far as the analysis goes, when you've got a summons that says that not to be found and then evading service?
That's an open question, I think, and I think that's why we're here today. But it's my contention that, I'm sorry, I didn't mean to interrupt you.
Well, you didn't appeal the summary judgment, though, did you?
I'm sorry?
You didn't appeal the summary judgment.
I didn't? I thought I did.
I don't think so, did you?
Yes, sir. I think I did.
Let's see. What was your issue?
The issues?
Yes, sir.
The issue was, did defendant comply with 56-7-1206D and her failed attempt to serve the uninsured defendant so their claim may proceed against her uninsured, underinsured motorist carrier, which was properly and timely filed.
And no question about the trial court granting summary judgment in there, is there?
No, sir.
Okay.
They granted motion for summary judgment saying that we did not comply with the terms of the statute because looking at subsection E, the way the trial court read it, we had an additional burden in the event that there was an evasion of service or process notation on the summons to continue to seek service on the defendant.
Okay.
And I disagree with that. I think that the statute's clear, and that subsection D says that we did everything we needed to do to comply with the statute, and we should be able to proceed forward with the case against the carrier in the place of the uninsured defendant. All right, that's all I have. Thank you.
Thank you.
Good afternoon, Your Honors. Bailey Walden on behalf of the appellee, Progressive Casualty Insurance Company, the unnamed defendant and uninsured motorist carrier in this matter. As Your Honors just heard, there is no dispute that this case arises from an automobile accident and that plaintiff appellant's complaint for personal injuries was timely filed within the 1-year statute of limitations. However, the issue is whether her claims against both the uninsured defendant, Neal, and against her uninsured motorist carrier, the appellee in this matter, are time barred. Rule 3 of the Tennessee Rule of Civil Procedure states that an action is commenced upon the filing of a lawsuit. However, a plaintiff cannot rely upon that filing date to preserve and toll the statute of limitations if process is either unissued for 90 days or remains unserved from 90 days of issuance. In order to rely upon that filing date for statute of limitations purposes, a plaintiff must reinitiate the action by obtaining a new service of process within 1 year of either the previous process issued or within 1 year of the filing of the complaint. That was not done here. As was discussed, there were 2 summons that were issued to the uninsured motorist, Mr. Neal. Those were issued in November and December of 2022. I do believe that in the record from the trial court, there was an error in the date. It listed February 14th, 2023 as the date of the second summons. That is actually the date that the first summons was returned, just to clear up any confusion with the court on that matter. The first summons that was issued in November 2022 was returned unserved on the February 14th, 2023 date. The second summons that was issued in December 2022 was never returned to the court. The summons that was returned contains a stamp on the first page that states not to be found after diligent search and inquiry. And the second page contains the written certification of the process server that the uninsured motorist was not to be found after diligent search and inquiry because he was, quote, avoiding service / said he would not cooperate and enlisted the phone number. No further action was taken by the appellant to obtain service on the uninsured motorist, including the procedure very clearly set forth in Tennessee Rule of Civil Procedure 4.04 subsection 4 that sets forth the process to obtain service on someone who is evading or attempting to evade. It is the position of the appellee that the statute of limitations was barred against the unnamed and uninsured motorist, which then in turn bars any claim of relief against the appellee, the uninsured motorist carrier, progressive casualty. As set forth in Winters versus State of Jones, there can be no liability against the uninsured motorist carrier when the statute of limitations in service was not properly perfected on the uninsured motorist.
Is the process server able to make the statements that the process server made on the return?
I'm not aware of any reason why they cannot make a statement as to what prevented them from fulfilling their service duty.
Well, is that what the process server did?
Is what the process server did, Your Honor?
The process server made the judgment avoiding service, said he would not cooperate. Do you know any more about this service of process than opposing counsel does?
I do not know any more, Your Honor.
No deposition, no other information?
That's correct, Your Honor.
So is the trial court then able to take a statement like that, that the defendant is avoiding service at face value?
I think the trial court has the ability to take that at face value if there is no objection raised as to the potential hearsay of that statement. And it would be my position that it was made as a certified statement by the process server in that summons return.
Isn't that just hearsay?
I suppose that there could be an argument that there is hearsay, Your Honor. That was not objected to in the original briefing, and it was a statement of undisputed fact that was admitted by the appellant in the briefing.
Okay, that was admitted to?
Yes, Your Honor, and I'd be happy to look and find the page of the record to direct you to.
No, that's okay. We'll do that.
May I proceed? Thank you, Your Honor. The appellant argues that she is relieved from complying with Rule 3 of the Tennessee Rules of Civil Procedure by Tennessee Code Annotated 56-7-1206D, which provides that in the event of service of process against the uninsured motorist, which is issued to the motorist's last known address and is returned marked not to be found in my county, or words to that effect, that the plaintiff can proceed directly against a served uninsured motorist carrier as if it is the only defendant in the action. However, it is our position that this statute is inapplicable to the facts of the case, as the uninsured motorist's whereabouts were not unknown. There was a conversation with the uninsured motorist that led to the statement that they were refusing to accept process, and a phone number was listed.
But we don't really know what conversation, if any, actually happened, right?
That's correct, Your Honor.
For all we know, it could be a neighbor said he's not going to, because what's written on the summons doesn't say who said it, does it?
It does not, Your Honor. It just says avoiding service / said he would not cooperate.
So hypothetically, if that note wasn't on this summons, if it only said not to be found, we wouldn't be arguing about this.
Agreed, Your Honor.
And you have no information about the phone number that's contained there either, I assume?
Correct, Your Honor. This court has held that statute 56-7-1206D is not an empty formality and that there is a diligence effort required of the plaintiff to preserve both the rights of herself or himself and of his or her insurer. Here, it is our position that there was not a diligent effort shown, as after this summons was returned unserved, no further effort was taken. The second summons that was issued in December was never attempted to be served, or if it was served, it was never returned to the court. And therefore, it's our position that 56-7-1206D does not apply and does not relieve the appellant of her requirement to comply with Tennessee Rule of Civil Procedure 3.
Because it was never returned, does that have any legal significance as far as the summons itself?
Your Honor, my position is that the summons that was returned does not comply with 56-7-1206D. In terms of the second summons not being returned, that does not necessarily have a significance other than there is no way to know whether effort was made or whether he was indeed found, not to be found, arguably not to be found, otherwise we wouldn't be before Your Honor today. There was one of the cases that was cited in the briefing that discussed that there was not diligence of a plaintiff's counsel who obtained two different summons, one for the uninsured motorist who was believed to live in Switzerland, and that was returned with some handwritten notations, but it was unclear whether there was actually a personal service effort made. And then the second that was just retained by the attorney. And the court found that there was not due diligence or the diligence that was required of 56-7-1206D in that specific circumstance. It would be our request that the court affirm the trial court's dismissal of appellant's action against the uninsured motorist and against the uninsured motorist carrier. Unless the court has any additional questions, I will conclude my argument.
Thank you.
Thank you, Your Honor.
I believe you got your 2 minutes.
Your Honor, I don't think I'll need them. Obviously, I'm going to argue that I was diligent in serving the defendant and that when it was returned not to be found, in my estimation, that complied with the uninsured motorist statute and that's all we were required to do proceeding as CUM carrier. And that's all I have.
Thank you.
Thank you.
Thank you. Thank you, counsel. We appreciate your briefing, your argument. We'll take this matter under advisement and attempt to get you an opinion as early as possible time. You may be excused.